Well, welcome everyone to our second CSBARS meeting of 2022. It is March 16th at 1 p.m. So we're about to begin. Ms. Leonard, can we do our roll call, please?
Yes. Jay Frickberg,
Present.
Michael Clancy,
Present.
George Leo,
Present.
Jessica Park,
Present.
Linda Keller,
Present.
Paul Kramer,
Present.
Greg Murphy. We have a quorum.
It's now time for our public comment, if any. Please be advised, again, if you are attending telephonically, you must press *9*9 on a phone to indicate you want to raise your hand for that. At this time, do we have anyone requesting public comment?
No, we do not.
Moving on, our next issue is our approval of minutes from our last meeting in January. The minutes have already been circulated prior to this meeting. Is there any additional time from anyone on our committee to review those minutes? Anyone requesting additional time? Hearing none. Is there any discussion needed to correct anything in the minutes or a motion to adopt the minutes as submitted?
I'll make the motion to adopt.
I'll
Is there a
second the motion.
Ms. Leonard, can we have a roll call vote, please?
Yes. Michael Clancy,
Aye.
George Leo,
Aye.
Paul Kramer,
Aye.
Linda Keller,
Aye.
Jessica Park,
Aye.
and Jay Frickberg.
Aye as well.
The motion carries.
Thank you. We can now move on to our noticed agenda items. I believe Ms. Leonard, you're beginning with our staff report.
Thank you. Thank you, Dean Frickberg. So I have several items to share. The first one is just to give everyone an update on the staff review of the 2021 annual reports. Many of you already know, you've been contacted with us that this is going on right now. There may be questions along the way. The first thing you'll see is this week on the committee's Friday agenda for those schools that had progress reports stemming from their inspection reports. Those progress reports will be presented to the committee of bar examiners. For those schools that helped us to clarify and correct numbers, thank you very much for that. We are nearly complete with our 6061 audit, and we appreciate everyone's cooperation in those steps regarding the annual reports. Next topic is registration as a law student. This is certainly not new information, but it's a good moment to remind people, but also seek a little feedback from you at your schools about how important it is for students to register within 90 days of beginning their law study. And more recently, we've seen a little bit of a downtick in that number. And it would be helpful to know either in this meeting, or I can send a follow-up survey afterward, if the school is taking any steps right now to encourage those students to register, or alternatively, if you would be willing to do it in the future, or what you think the obstacles could be. And so, for example, Chair Frickberg, at your school, are you checking in on the students as to their registration? Are you informing them? For example, how is that handled?
Within our institution, it's been a perennial problem, I would say, in that the students will register with the committee, but we do not receive separate information evidencing that, because it's communication between the student and the committee, and we're not being notified. One of our resolutions attempts in that area is we've included as part of our course content in our first course called Intro to Legal Studies, where we have an entire discussion of the life cycle of becoming an attorney, from pre-legal education to the oath ceremony, and then we touch on that registration process there to encourage them. I'm definitely open to any other ideas of how we can evidence it in documentation and then have individualized discussions with students, but I'm not aware of anything we can do besides that currently.
Mm-hmm. And if we would use the raise hand feature for our panelists, which we don't do that often, how many schools have a step like that, the way Dean Frickberg described, in which in a class, either you tell people about the obligation, or you ask them if they've already done it. So let's start with, do you tell them about it? And it looks like I see 3 hands and 4 with Dean Frickberg, 5. So it looks like people are telling the students about it. And then is there a checkpoint after that at any time to just say, hey, how is this going? Has this been done? Is there an attestation in any of their campus records, things like that? We're finding that, yeah, Dean Frickberg, are you raising your hand or voting?
Oh, no, I was raising my hand, although it seems to match when I do the virtual voting as well, the skin tone of it.
Okay.
What we found institutionally is this comes up a second time within discussion of the professional responsibility ethics course, because that's when the students are focusing more on the relationship with the committee, contemplating beginning of the moral character process, and of course the current incarnation of the moral character process, you have to be able to log into the system, and thus you have to be a registered law student. So that seems to be the next pressure point of where internally our conversation is occurring.
Mhm. And there are several advantages for students if they do register right away. So for example, from time to time, the State Bar has notices that we send out through the deans, through our social media, other places. But when a student has registered, we're able to also contact them directly. For example, to tell them about the State Bar webinar that's happening next week, or other opportunities. They will also reduce confusion. One of the #1 questions we get is the difference between registering and filing an application to take an exam. And we know that that's coming from a person that's doing them close in time, because if they had registered at the start, then they would probably know the difference. We always help them and get them where they need to go. So I will send a little follow-up survey after this meeting, in case people have any thoughts about what could work well, what obstacles could be, and just to remind people of the advantages to your students to do that timely registration.
Natalie, if I could just add a comment or two in second Jay's comment, and again, not to provide or request even more work for staff, but it would be very helpful to get, if you could program Ames to send an email to our registrar whenever one of our students registers with the bar. We know. I mean, we try to dog them. We talk to them. We have a pre-course student orientation, and we give them the drill about the necessity of registering. And then in the early couple of weeks, we send a reminder. But beyond that, unless again, because we're so small, I will raise it individually. But and the only feedback I've heard, and this is just purely anecdotal, and honestly, law students, on this point aren't entirely credible. Those who have registered said it's not as easy as it should be. They've had to search the State Bar's website looking for the way to register. So I don't know if that's in fact true, but knowing who hasn't registered, what we're very scrupulous about, of course, is the 45-day rule with regard to getting transcripts. So we should probably do a better job and get everybody who, and that's not been an issue for most of our students. So that's where it kind of drops off. So if we knew who registered, and we would then know who hasn't, so that might help. But we'll do a better job than we might have been doing to get everybody registered as soon as possible.
Okay, and I've asked Patty Salazar from our Office of Eligibility to join us today. She's in the audience and she raised her hand, which means she might have some helpful information for us. So I just set her to be able to share with you, Patty, if you'd like to make a comment. Perhaps not yet. I'll keep your line open, and it looks like we might have a question. Oh,
I'm
Patty?
sorry. Okay, yes, I'm sorry. So let me see here. Okay, so yes, once the registration is approved, the applicant does get an email confirmation. So my suggestion would be, once you tell your students that they need to register, let them know to forward you that email that they receive. That way you could add that to their file and you'll know who's registered and who's not. And I think that's it.
That's a very good idea. And Patty, if they don't hold on to that, are they able to print out or resend any type of a confirmation from Ames?
They could, well, that's an automatic email, but they can always submit a general request through their applicant portal and email us and let us know that they would like a duplicate registration confirmation email, and we'll certainly send that out to them.
Great, thank you.
Okay. Mhm.
And then it looks like there's a question from Dean Park.
Yes, no, thank you. Actually, my answer got questioned, so thank you, Patricia. I was curious about if there is some sort of confirmation, because as you said, sometimes students can mistake what they're doing on the portal, especially if they are very new to it. So it's great if there's something objective beyond it, attestation from them to sort of evidence the registration. The question I had actually came out of how ALU talks about the registration process with students, which we do in our new student orientation. And we include the URL where students can register in that presentation so that they do see that. But when they come to the page, it's a very blank page. There's not necessarily a lot that lends itself to tutorials or a manual on that page. And I'm thinking if we want to encourage especially new users to register into the system, it's really their first interaction with it. Something like a manual or a tutorial would be very helpful because then, you know, they kind of get into it and do it the first time they visit the URL versus kind of sit back and say, oh, I'll address this at another point. So is there anything like a manual for Ames for users? Or even just something brief that can be very targeted towards first-time users?
I'm not sure if there is a specific item, but I know that that is something that we are thinking about internally. What are the sorts of things that might be helpful now that the AIMS system is a little bit more mature? We've been working with it a little bit longer.
Well, and I do want to say that we do share various AIMS processing steps for various functions. For example, when results for the bar exam or for the first year exam are made available, in our email, we include the steps that you need to take in the AIMS portal step by step, where you can find access your results, where you can find your exam booklets for those unsuccessful applicants. And so while we don't have a manual itself, there are emails that we send out even for registration. I'm trying to think of another one. For PLL, we had the steps that were taken. So, you know, while there isn't a manual, I think staff make an effort to provide the steps that people might be asking about or inquiring about for any of the applications or process of the application. But I think it'd be a good idea, what you're suggesting, Dean Park, to maybe put those all in one area on our website potentially is a good idea.
And I just think, I know that we're giving them the URL. It's possibly once they visit the URL for the first time, you know, they might not need everything. They just might need a 1-page or a mini tutorial. Just, we know you're here to get registered for the first time. And that way they won't kind of drop away from doing the task, even though we gave them the URL.
And every so often we bring this topic up, and I'll tell you about a couple of things that I remember from a past meeting. For me, myself, when I was in law school, we actually at our orientation had a session where there was time set aside in the session. You know, if you be prepared for the fee that will be required, the information you'll need. And at this point in the session, everyone will register and we'll circle back. But another school actually even asked the students to submit proof of registration. And if they did so by a certain day, they did a raffle. And everyone who was registered could be entered in that. And they won a prize. So that was the most unique thing that people were doing that I have heard of. Okay, and while we have Patty here, I'm just going to touch base to see if she has any other comments.
Yes, Natalie, I was also going to mention at the last registrar meeting, we did have Selena Flores do a run through of of an applicant submitting a registration. And I know there was a lot of positive feedback on that. So perhaps we can repeat that at this year's registrar meeting. I think it would be very helpful so the law schools get an idea of what the applicants see.
That's a good idea. And I wonder if that's something we could even record. We will need to look into that.
Mhm.
Well, thanks, Patty. Thank you for joining us for the discussion. Okay, any
Thank
other
you.
questions on this topic before I move on to the next one? Okay, this is not usual that the staff report is all me, but today it will be. Okay, just a reminder regarding the NPR, because we're starting to get questions. Accredited law schools maintain an NPR of 40% or more. And you know that once the results from the February bar exam come out, the accredited law schools will be able to begin to calculate that number. Just a reminder that this year we are incorporating those individuals who are in the PLL program in the pathway to licensure. And just as last year, each school will calculate its NPR using the pass-fail lists. They'll turn in that number in draft format as with last year. And then the State Bar will provide an adjustment number indicating how many people are still in the pathway. Theoretically, everyone should have completed it or withdrawn from it because the program will sunset on June 1st. And then also those that have licensed. So we just wanted you to be prepared for that step. We were getting a few questions about when the PLL numbers would be received. And just a reminder, the State Bar has made a commitment that those who choose to license via passing the bar exam versus those who choose to license via completing the pathway will be treated completely the same, and they will not be identified differently on our State Bar attorney search. And that's part of the reason why we give you an adjustment number rather than a list of names. So this is really just repeating the process that was in place last year. And it's just a quick reminder because we received some questions. Any other questions on that? Okay. All right, thank you. Also, just a reminder, CSBARS and also law school council applications, the deadline has been extended from March 1st to April 1st. And so if there are deans or administrators in the audience that are interested in serving on CSBARS, or if there are ABA approved law school deans or administrators that are interested in serving, this would be the time to apply. I don't know if there is anyone currently sitting as a member of CSBARS that would like to talk a bit about what you've enjoyed about your service, or a tip for someone who might be applying for the first time. Dean Frickberg?
Well, as mine will be one of the vacancies being filled, I think it would be useful for me to give my view on it. I've volunteered for the past couple of years, and at first I wasn't sure how well it would work, but again, it's worked amazingly well from my perspective. As you can see with the new rules that were adopted and came into effect January 1st. Can things always be better? Absolutely. But the only way things will be better is if you're part of the solution, right? If you come in, you lend your voice, you put your concerns forward. It's a very open discussion, and it's a public discussion, which is excellent. And I would encourage everyone to participate, whether you're going to come in for public comment or you want to throw your hat in the ring to be a member of the CSBARS. Again, this has been a very good positive change that I've seen over the last couple of decades of California accredited law schools. Thank you.
Sometimes we get a question about the time commitment. They can hear the answer from me, but they might prefer to hear it from members. Any thoughts about that?
I can give my view of it. I think it's very similar to when I talk with students, how much time do I need to study for a class if I'm teaching contracts? The actual commitment for this meeting is just a couple hours. However, for all of us, we take things very seriously, the research, the delving into the data, to make sure that we're conversant and ready for the conversation. So I think if you're interested, it won't be a burden, but it will be a time commitment. It is a serious dialogue because it not only affects us individually in our institutions, but the entire state and the opportunity mission of diversity, equity, inclusion that the State Bar and many of our institutions are built for.
Okay, thanks, Dean Frickberg. And then finally, I have just a couple of announcements about recent developments. The first one is a reminder. We sent out an invitation to all of the law school deans to encourage your students to register for the State Bar Day webinar that takes place next Tuesday. We'll have members from OCTC, our Lawyer Assistance Program, of course, the Office of Admissions. They'll do a 1-hour presentation starting at noon, and then there'll be a half-hour open session for general Q&A. So far, when we've done this, we've reached max capacity every time. So we encourage you to share that with your students. And in addition to the email, we've also announced it on Twitter, the State Bar Twitter at StateBarsCA, which I'm sure all of you are following. So people can refer to that as well. And the Twitter link can also be sent as a text. I know that some students prefer to receive their information in that way. And I also want to share a couple of opportunities for your professors who may also be California bar licensees. The State Bar is offering 2 educational opportunities for State Bar licensees. The first one is the Ethics Symposium, and this will be taking place on Friday, April 15. The signups are on our website. This is a free program up to the max registration of 1,000 attorneys that attorneys can take and claim MCLE ethics credit. And you can hear the information directly from the State Bar and other ethics experts. The second one is a new course on implicit bias, which yes, you can also sign up for again through our Twitter. It is an MCLE credit course, and it is also at no charge. So that's something that you can share with licensees generally, and also your professors who may also be State Bar licensees. And then finally, for those of you who have been thinking about participating in the campus climate survey with the National LGBTQ Bar, but you haven't had a chance to do so yet, I will admit the deadline has just passed, but they've let me know to give them a call. They'll make sure that you get a copy of your school's own unique link, and you will be able to participate in that survey if you can contact them in March. Finally, just a general announcement. We've been talking about the issue of student mental health during the pandemic. And one thing that some schools have been doing, I received this tip from the University of Illinois at Chicago, that Down Dog, which is a commercial provider, we don't endorse it over any other, but they are offering meditation, yoga, workout, exercise at home for educators and students through the end of the school year at no charge. UIC had it on their website, and they said it's been popular with their students. So share that in case that may be helpful. And that concludes my staff report.
Thank you. So now we move on to our last agenda item, and this is a continuation of our previous meeting, as well as a continuation from the prior committee of bar examiners discussion. Specific, talking about the registered unaccredited law school guideline 1.11. Context again was prior, there was a limitation on the ability to award credit for courses for bar review, and then there was a waiver issue. So I was wondering if this is a good time to show some of our slides to show the background story of what guideline 1.11 schools.
I'm happy to do that. Okay. So this is a recap of the action that the committee took in January regarding unaccredited guideline 1.11, which relates to exam preparation classes. This is the actual motion that was passed. Because it is a longer motion, I'll summarize it, but give people an opportunity to review it. The first action that the committee took was to ratify the existence of a waiver of this guideline at this time. And we know that several of the schools have been using this waiver for some time. It was originally passed in 2009. And the committee asked, given that a certain amount of time had passed, they referred it back to you here at CSBARS to discuss what the current factors were, thinking about how the guideline should be amended, if it should be amended. Any questions so far regarding this motion, or Paul, because you were a voting member of the committee, any comments about the motion itself?
No. I just point out though that, we are starting to look at the, we are starting to look at the rules and the guidelines for the unaccredited registered schools. So whatever the final decision is would be wrapped into that, presumably.
Okay, thank you. In terms of timing, the committee has asked for your feedback to be presented to the committee at the August meeting. So in order to do that, you'll have 3 opportunities to meet and discuss, including today's. Prior to that, March, April, and June. The reason that I don't place August on this is because by the time of your August CSBARS meeting, any staff memorandum or preparatory material for the CBE will have already been posted. So I would recommend that you finalize your recommendation in June. You can talk about the staff memo or any other comments in August, but it will be quite close to the committee's discussion. And Dean Frickberg, I don't know if you want to talk a little bit about this division of tasks that you had asked me to share, or if you'd like me to do that.
Sure. So in contemplation of our meeting, I tried to think of a structure for the dialogue, and especially since we have a luxury of time, as we can see from this slide, with the idea being looking through guideline 1.11 through multiple lenses. There could be the lens of the contrasting ABA approval versus California accredited versus registered unaccredited. What are the distinctions? Should they impact this? But then also looking at the pillars that we've discussed within the CSBARS previously. And I think if we take each of those lenses, we can have a discussion of pro and con, and we can create smaller working groups of 2 committee member individuals to research, to come back with drafting ideas in each of those lenses. And then when we meet again in April, then we can have a drafting session with a presentation of these different pros and cons, and hopefully come to a good resolution at that point. I did put together some proposed team groups with the idea being that we would team together one of the deans from a registered unaccredited with an accredited dean, and then our ABA consultant with our accredited school that has an ABA history, because they would speak the same language. I thought that would help the subtle nuances come through within the conversation, make sure all voices are heard.
Would you like me to skip to the team slide?
If we want to go to the next slide, actually, we can just see those lens. Okay, sorry, I had to order my mind differently. So these were the proposed teams. I don't know if there's any discussion with the teams being that they could meet with a shared drive, do some proposed drafting of what they believe as a team guideline 1.11 should say through a certain lens, and we can talk about which lenses each team could work on. Any discussion on that, or pro con just on the team idea?
This is a concept that we used during the drafting of the accredited law school rules, and I feel like it worked very well. Okay, so just a reminder for people as to the current rule. This is the current unaccredited guideline 1.11. And I don't know if someone would like to read it for those that would prefer to hear it verbally, that may be watching from their office places.
Well, if it's helpful, I could read it. I might put somebody to sleep, but I can definitely read it. Guideline 1.11, first year law students examination and bar examination review courses permitted limitations. A law school may offer and charge for a first year law students examination and bar examination review course. Any such review course must not be part of the credit requirements to obtain a JD degree. The law school may not condition any student's continued enrollment or graduation on the student taking a review course offered by the law school or otherwise. The law school may also permit commercial first year law students examination and bar examination review courses to post advertisements and promote their courses to law students. Law school administrators, instructors, and staff must not compel or solicit students to attend any particular review course.
Thanks, Dean Frickberg. And the committee offered a starting edit not necessarily wedded to this edit, but just to get the process going about what a new guideline could look like. And the deletions are bolded in red and strike through. And I'll just ask Mr. Kramer if he has any other comments about this initial edit designed to just begin the discussion.
Okay, I'm just reading it here again. No, not really. It's I think it was removing the well, actually, I'm not sure. Natalie, you're gonna have to refresh me on the history of how this came about, because I have a sense that there was a self-dealing prohibition aspect to this in its original pronouncement, and I guess I wonder if the struck longer sentence isn't still perhaps somewhat relevant. In other words, should a school be allowed to require a student to take a particular class, or simply allow them to choose it at their option? So I frankly don't recall when this edit was made.
Okay, yeah, so the original waiver was passed back in 2009. It was meant to be very temporary, and the thought was that the guideline would be changed then. In fact, it was not. And since that time, so much has changed in the legal education landscape that I would encourage people to look at the current state and look forward and see what might be appropriate and what factors might be appropriate. But I do think that some of the things that you raise are an issue. On the one hand, of course, most law students will plan to take the bar exam and license, and becomes a question of where the prep class belongs, where the financial incentives are, what will best prepare the students for licensure.
So it might be useful for me to state my questions so that the teams at least have them in mind as they're going forward. And they are, and you just raised a variation of one, I suppose. If somebody is just getting a JD degree and doesn't plan on taking the bar exam, they would probably find it to be, imposition on their time to be required to take extra review courses. I mean, law school in a way is review for the bar exam, but it should be so much more. And my concern, and the reason for the question in the referral about whether there should be some limit placed on the amount of bar prep courses that could be taken for credit against a JD, is a concern that the breadth of one's legal education might be vastly reduced if there is a significant focus on simply trying to prepare for that subset of all the topics that a lawyer in the world will confront, rather than providing a broad legal education into other subjects that aren't tested on the bar exam.
Thanks, Paul. And we're going to be capturing these questions and some others in a few slides. So this first group, this is one of the analyses lenses that Dean Frickberg talked about, what's going on today with the American Bar Association approved schools, the California accredited schools, and what could be going on in the future with the unaccredited schools, including their unique requirements through the BMP code 6060 4-year rule, and also attendance requirements as well.
Natalie?
Yeah.
I think you have some, Linda has her hand up.
Oh, sure, Dean Keller.
No, that was no problem. I'm glad you got through that slide, but I appreciate it. I'm wondering if we could maybe take a step back for a minute to make sure we're all on the same page in terms of what we mean when we say bar preparation review or bar examination review or preparation course. I mean, I know I look at the accredited rules and I have a certain interpretation of what I think that means, but I think it'd be really helpful to hear from you or from Mr. Kramer on what meaning you guys are giving that particular term before we try to come up with our, team approaches.
Well, and I think that would actually be one of the topics of discussion, because this is the feedback that I've gotten so far. Of course, there are commercial bar exam preparation providers that have specific courses. I think we can all agree that those are bar preparation programs. Inside, some schools teach their own in-house created bar preparation programs that are so labeled, but still other schools have legal research or legal writing type courses. And in some schools, they consider them to be bar preparation, and others they do not. So I think that is an interesting part of the discussion. Others have study labs that are required or optional. Some class them as bar prep, some do not. And still others weave what they believe to be bar preparation into their everyday courses. So I think that's a wonderful question. And it's a query whether the rules or the guideline information surrounding it might be different depending on which of those formats is being used.
Okay, so the idea then is that would be part of the discussion in the teams as we're looking at whatever lenses we end up looking at. We're going to say, okay, we're defining it this way, and therefore this is our recommendation. But another team might say, oh, we're defining it differently. And so then I guess that lends itself to the next question is, how do we compare, let's say through this lens, ABA, CALS, unaccredited, if we're all using different definitions of what we think bar review course should be?
And maybe it would be helpful if I would just share some of those different formats. Where those formats came from was we did a survey of all of the unaccredited schools, and we asked them what they were doing today. And for each one of those formats, I got that answer from at least one school. And so I think maybe it might make sense to make that available to all of you. And you can talk about how your recommendations might apply in each of those scenarios, so you know what it is that the state bar is addressing in the guideline. I think maybe rather than potentially using different definitions, we might make them all available and see if the different formats make a difference. Okay. And then Dean Keller, while we're speaking, I didn't know if you might want to take a moment to talk about during the school's time as an ABA school, how you handled bar prep, or how the school handled bar prep at your school.
Sure, happy to do that. I mean, like for every ABA school that I know, as soon as the ABA changed its rules to allow 4 credit bar preparation courses, virtually everyone started offering them. And the way that it was interpreted there is a bar preparation course was a last semester course that was designed to feed into a post-graduation course. So like that's the interpretation that I give that particular term. But as you notice, there could be many others. So that was sort of the type of course that related to the ABA rule. However, best practices in the ABA for ensuring bar success on the bar exam and in practice was really to integrate bar prep throughout the entire curriculum, particularly for schools outside of, say, the top 20 that are made up of, extraordinary test takers going in. So, and I believe that is still, the approach for ABA schools in terms of having that last semester course that feeds into whatever commercial bar prep program schools are students choose to take, but most have additional classes, either standalone or additional programming that's integrated into their case-based courses, their legal writing courses, and even their electives throughout the entire curriculum.
Thank you. And is it generally required, this course, this on-ramp course?
That depends on the school. Many schools, it's just part of the curriculum. At other schools, it may be required for certain students depending on GPA or other cutoffs. So it does vary.
Okay, thank you. Any other questions for Dean Keller as to the ABA schools? Not that she was prepared to be the expert on all schools today. Okay, and then thinking about the
I could just jump in for 1 second.
Sure.
And I think this is why having a research component and then a presentation in April will really lend to a much better product that we can produce then in June before the August. As an example, looking at the lens just of accreditation, currently the ABA and California accredited schools would be unregulated in this area, so the definition was not relevant. The definition, we never had to come to that point. I think many of us informally might define it as the capstone course at the end of our curriculum to engage them for their licensure test. I think another interesting component for our community member Kramer is that, and that's why I wanted to make sure we have that lens of the unaccredited registered schools. They have the separate barrier just for their educational JD of the first year law students exam. So everyone who goes to an unaccredited registered school must take and pass, versus many of their ABA and California accredited brethren will be exempted so long as they complete their first year in good standing. So they must, right, just to get their JD degree, they must go through at least this first year law students exam process. And I think there is an educational benefit to that, even if they never wish to practice law. And I think that's one of the things that will come out from our lens analysis of just accreditation, ABA versus California accredited versus registered. And I think Dean Lill has his hand up as well.
I do, if I may. Yeah, thanks, Jay, for bringing up the point that I wanted to make and emphasize is how essential for my students getting as prepared as possible to meet the challenges of the first year exam is essential for their future, law career and hopefully becoming a licensed attorney. I also want to thank, staff and the committee. This is precisely the kind of discussion that I think is obviously long overdue, but on a very critical issue to my school and to others like it. I also second the idea of having an informational session, almost like a best practices discussion. And just a little insight, I have to be careful because I'd be literally talking on both sides of my mouth. One of the things I discovered when I became dean of my school was, again, how poorly my students were faring on the first year exam. And I looked into what had been done, and the school had hired, a commercial prep course to provide a first year prep course. And it really didn't, as I say, move the needle. It virtually accomplished nothing. So one of the things I'm most proud of is we've developed in my school a very comprehensive first year boot camp, and it's starting to show some effects, and it's quite rigorous and quite lengthy, and certainly deserves credit. So that's all homegrown. We use among our best professors who are highly motivated, and it's going well. On the other hand, I've just for folks that will be taking the July bar, I've got 2 graduates, and I wanted to offer them some help. But developing a bar prep course internally was honestly difficult. And so I looked outside and found someone I think is well qualified. He's a bar tutor who has been tutoring individuals for close to 40 years, a former district attorney, assistant district attorney in LA, and has been helping people and specializes with students with English as their second language in getting them ready for the bar. So We've been working with him this semester, and so far I'm meeting with him. In fact, he's flying from out of state. He teaches online on Friday. And I think and hope the students' reaction has been positive. So I again, favor homegrown programs, but I think there is something to be said for the right outside consultant or independent contractor that could come in. But mostly just to find out from other schools. And Natalie, I think we responded to that survey. I don't know if the results have ever been published. It'd be interesting to know. I think the problem that a lot of the schools had is, given the unfortunate stealth-like quality of this email, of this guideline, with the the memo going out from Gail way back in 2009, and then having no other formal recognition that schools have been free since 2009. Unaccredited registered schools have been free to offer first-year prep and bar prep. Not as many schools perhaps do offer it as maybe they wanted to. So getting the word out, I think, has hopefully been helpful in finally getting resolution as to what schools can do would be, immensely helpful for planning purposes. So if we can talk more about this, and perhaps I can get other deans of other registered schools to perhaps make an appearance at the next meeting to discuss what's worked well for them, and really talk about the success that I think some of these programs have had in helping students first pass the first year exam and then later on the bar exam. I think it would perhaps provide some comfort to the committee and Paul to see how beneficial these academic units can be. And our students, give you an example, our most recent graduate who just passed the bar exam on his first try did so at the age of 66. He's a CPA. And is already working at a well-respected firm in LA. And so I think he would be the first to tell you that he felt that, his curriculum and what he was able to do in terms of getting ready for the bar was essential for his future professional success. So the more we find out about it, I think it'll help all of us, come to a reasonable conclusion as to both the efficacy and the benefits offered by these programs.
Well, Dean Leal, I want to recognize your success, and also to thank you for thinking about the types of metrics that you use to determine what would be appropriate for your students, how you measured and how you adjusted. And I think that those will be interesting factors to enrich the discussion as well. So thanks for getting that started. And I also think there'll be the additional element, if the unaccredited schools work with a course that is created outside, will the course fit within the 4-year rule, the strictures of BMP Code 6060, whether for correspondence, for distance schools, or for a classroom, fixed facility classroom, each of which has its own standard. So Dean Frickberg, may I turn it back to you regarding the analysis lens that is the pillars for accreditation?
I hate when I do that. As we were discussing the lenses, I think we should all have the mindset to look through the lens of accreditation, ABA versus Cal Accredited versus registered unaccredited. But now I think when we work into our teams, we can be more specific. And I'm just very mechanical, elemental from all my teaching of contracts law, that I thought we could start off with, if there's no objection, of using the same pillars that we discussed within CSBARS previously. And that we could have each team assign 1 or 2 pillars just to research and see what are the pro-con arguments for drafting. As an example, the consumer protection and transparency, I've heard echoes of that in our discussion so far. Should it be in-house or contracted out? What is the payment structure for that? Is this something that a student really benefits from if they're not going to ever be a practicing lawyer? To me, that would be consumer protection, transparency. Student success, I think also it goes into that same vein, in that how do we define student success? That varies. As I've discussed with my institution from surveying, typically 96% of our students want to be lawyers. I'm always surprised by that. That 4% never want to be a lawyer. They just want the law school JD education from historical surveying. Maybe that is different in the registered unaccredited sphere. maybe that this is more focused on the first year law students exam rather than the general bar exam. So I think how we define student success will be another interesting lens for that conversation. And then of course, the diversity, equity, and inclusion, are these licensure exams themselves, are they bars? Are they making it more difficult without an added benefit to diversity and equity inclusion within our profession, which of course should reflect the community of the state of California that we serve. And then ideally preparation for licensure. I can't think of a better example of what preparation for licensure would be, but a bar exam. So again, this is just me being mechanical and going from what we've done in the past and what I think was helpful in the rear view mirror. And the idea being, if there is consensus on this, that we could assign these different lenses to those proposed groups. I don't know if there's any discussion on that before we go into a finer detail on it. Okay, not hearing any. Ms. Leonard, if you'd like to go to the next slide and go into a little more detail. So these are just some idea talking points. Is one course best for all students? And again, I think that is a very good macro level too, because the registered schools service a different population. Different registered schools themselves service different populations, depending whether they're in the state. Are they in a rural, are they in an urban environment? Should requirements be different for in-house versus outside? I don't know. I think Leo was very eloquent in discussing his observations from his school. You know, there's some arguments of where it's homegrown, it is more effective. That's been my view, you know, personally for my institution. But that takes a lot of time and a lot of effort. And sometimes you need improvement faster, where you might need to hire an expert consultant outside. So I could see both arguments, but this should be what we're focusing on to discuss. And then I think this is even more important for the unaccredited registered schools. How do we award credit? You know, how do we evidence the hours, you know, that are a requirement under BMP 6060? How can we document that, especially if it's an outside provider, to make sure that the attendance and the hours, so that way they can satisfy their 4-year requirement to qualify for the GBX? Because again, we're not helping anybody if they want to be a lawyer and they don't meet the admissions requirements for the examination itself. And then with the members of the law school community has a financial interest in the preparation company. So I think that goes back to our lens of consumer protection and transparency. So if just transparency, if your school is doing business with fill in the blank X provider, is there a benefit separate from the educational one? And not that there's anything wrong with that in our capitalist society, but is it transparent? You know, is everyone aware of that? Is one of the things, one of the elements in play. So again, these are just the thought process that we're walking through. And then the team that's assigned to this can then do their own independent research, start a draft version addressing these kind of issues, or even more issues that they might see that we're not seeing right now. And that's the goal of this dialogue today, is just to flesh out what should we look into in more detail. Assign teams to look into that in more detail, have them present in our next meeting, then we come together in that next meeting and then draft a rough draft, as I would call it, proposal for hopefully adoption in June. Any questions or discussion on our first consumer protection and transparency slide? Dean Clancy?
Yes, Jay, will we be able to get a copy of your slides after the meeting? I'm trying to make notes now regarding what I'm seeing, but it would be better if I could get a copy of the slides. That would be great.
Well, as they are our slides as a committee, I would definitely hope so, yes. And I'll talk with Ms. Leonard, but I wouldn't foresee an issue with that. It's always a question of how do we disperse them so we don't violate any of our statutes. Hence the teams of people.
Got it.
So I'm always cautious on that part.
Not a problem.
Very well,
We can do
thanks.
that.
Another point on that, just to foreshadow discussion I'd like us to have today as well, and it goes directly to that, the question that Leo proposed about having other deans in the discussion. I think public comment is excellent for that. Again, we always have public comment available. And I think when we structure a timeline for the discussion we're having right now, as I'm calendaring things out, our next meeting is April 20th, I believe, unless there's been any changes, it's April 20th. My thought process being, if we could, as our teams get back to staff, probably by April 6th, in 3 weeks, in April 6th, that would then give staff time to pull those together, post it, that are 10 days prior. So that way anyone who's an interested member from one of these other schools, deans, could then have more informed public comment for us to hear as we start doing our draft process. I know none of us like timelines or deadlines, but just to foreshadow, I'd like us to lock down what our timeline will be by the time we end this meeting. And that's my current thought process on it.
And Dean,
Any other?
sorry, Dean Frickberg, if I might also offer an additional public comment opportunity. Schools can submit public comment between meetings. And if a school has an additional question that they would like to submit for the groups to consider, or a comment, or they'd like to talk about the program that they have, they can submit that in writing to me directly, or to the law school regulation at calbar.ca.gov box. And it would be extremely helpful to these teams of 2 that are working, and also to staff, to have as much public comment as soon as possible. So schools need not wait for the next April meeting. They can proceed directly from this meeting and provide a comment right away. And I would greatly encourage that.
And I would definitely echo and amplify that. In fact, I see, again, our committee is the CSBARS. We're just serving, in this case, the registered unaccredited schools and the populations they serve. And the more information we get before pen to paper, the better, always. I think in the same way that our committee member Kramer will echo that the harder we work as CSBARS in drafting and researching and discussing this point, the better ultimate result the committee will have, when they bring this in August for their discussion. So we're each just trying to help along that line for the finished product. So I would definitely echo and amplify that. Any other discussion on our consumer protection and transparency proposal? Okay. Hearing none, if we can go to our next slide, please. So academic success, and I think this is one that I remember Kramer was discussing. Is again interesting. How do we define success? Right. Again, in my experience, that has been very eye-opening as a dean, because each student, I've had students that they feel it is successful just to be admitted to a law school, to be the first person ever in their family admitted to a law school. Then, okay, I made it to the first year, I graduated, or I passed the bar, or I won my first case. All these different benchmarks. These are all different definitions of success that vary individually to the student, to the institution. So I think that could be a very robust analysis. And I think that will vary, again, as we were discussing, based on the first year law students exam. So I don't want us to fixate too much just on the general bar exam. I know that's what we think of when we think bar review, but it's equally, if not more important, to the first year law students exam, because unless they pass on their first 3 opportunities, that could be a bar on the completion of their JD studies at that registered unaccredited school, which could be their definition of success, right? Just to receive that degree. So what is the trade-off in replacing electives with exam preparation courses as to the person's future practice? And again, I think that varies. As an example, is it a required course, right? If it's a required course, then maybe it is knocking out another elective course. But if it is an optional elective, then that would take away that potential argument. Can the doctrinal courses be made to contain sufficient bar preparation? And I think this was Dean Keller's excellent point. What is bar review? I've taught contracts most of my professional life. Contracts as taught in law school, to me, is more bar review. It's not California practice. We're discussing the Uniform Commercial Code, not the California Commercial Code. Where do we see the UCC? We see the UCC on the bar. We don't see the California Commercial Code on the bar, as an example. So I think that how we define terms, and if the bar review is broken up, does it lose some of its benefit? Again, in the academic terminology of a capstone course, there is an academic advantage to have this summative review of all of your material before you leave institutionally with your degree, separate from leaving to sit for your licensure exam. So I think these are all excellent topics to explore. Any discussion from our group on student success? We can go to our next slide, please. And then diversity, equity, inclusion. To me, as everyone, as I've heard from me ad nauseum, I think this is a lens that I think we should always focus on. When I look at data from our membership, I'm always concerned about. Because again, we have to understand, I think our country does so well because of how we respect the law. And I think the more people of diverse thoughts, communities that we bring in, the more respect there will be of the law, and the safer, the better society we will have. And that shining city on the hill that we've always looked to. So this is a very important one to me, and this might layer into all the other areas. You know, what is diversity, equity, inclusion? How could adding bar preparation courses support or detract? Well, I think maybe not having a bar prep or not having that ingrained within your course structure could detract. Because as an example, a first generation person, you know, when I say first generation professional law school, they might not understand that you need a bar prep. Institutionally, I've seen this come through the LSAT as an example, where many applicants have no professional attorneys in their family, their community they converse with. They don't know the importance of studying and preparing for the LSAT as an admission criterion to get into law school. So they just sit for it. And I think that has happened as well for the bar and for the first year law students exam, where people feel, I sat in class, I understand my material, I have good grades, but the licensure test might be slightly different than what was being tested. You know, the difference I've always noticed is law schools go to a great depth of material, while bar examinations usually are more of a breadth of material. You know, it doesn't go to the same deep level when you know you're walking into a real property exam, and the rule against perpetuities might be a specter you have to be concerned with. Typically not so much on an essay for the California bar in comparison. So I don't know if there's any discussion on the diversity, equity, inclusion lens. Dean Liu?
Yeah, I just want to again backstop what you're saying, Jay, and I think it goes to a broader issue I meant to make earlier, a point earlier, is I would hope this is a good opportunity to better educate the committee overall as to, particularly with the registered schools, who our students are, and perhaps even with many of the CALs. You know, things have changed very dramatically, certainly because of COVID. Committee members aren't and haven't been on campuses, any campus, for over 2 years. You know, the better, from again personal experience, every time a committee member met with students face to face at any campus I was on, they always came away incredibly impressed with who was in the enrollment and often who was succeeding. And you know, their needs are so very different. And you know, again, we all have our own anecdotal examples. One of my students who passed the first year exam on her first try 5 years ago was in Vietnam. She didn't speak a word of English. And here 5 years later, she's a legal resident and is in law school, has degrees in Vietnam that qualified her for admission. And she's an excellent student, and she will, I think, unquestionably go on and graduate and pass the bar exam. So in less than 10 years, she will be, I hope, practicing in her community here in Orange County as a bilingual attorney. And so, and I'm pretty sure she wouldn't have been able to afford any ABA school for sure. So, you know, this is who we teach, and I know I'm speaking or preaching to the choir to some of us. You know, these are not folks in their 20s who, like I was, blessed in having parents who paid for my tuition and my housing costs and gave me the luxury of taking, you know, extra classes here and there because I thought it might be interesting. I think everybody that is on this committee are teaching folks that are looking to become licensed attorneys, with a rare exception. So the better the committee knows what they can do to help our students succeed, I think the easier it is for them to make these adjustments. So.
And just to echo on that, I thought there was an excellent discussion at the last committee bar examiners meeting when they were discussing testing and test creation. And there was an example given of a question that was written that involved a quote unquote SUV that most of us native American English speaker will understand as a car. But then why didn't the fact pattern just say car or automobile, a more generic term? And where some little change like that might throw off that examinee's discussion later. That's something that could be addressed in greater detail, I think, within a bar review type course. This is the language to be on the lookout for, especially as you're describing, because I've commonly had students, and it amazes me because I speak one language poorly, English. I've had students that are natives, their native language is Farsi. Then during their childhood, they moved to Russia, where they learned Russian. While in Russia, then they were taught English. So they actually learned English in their middle language, Russian, and now they're in law school. And I'm just amazed that they can put a sentence together, much less sit under a time condition test, translate this into a cogent analysis that is gradable. It's amazing. But I think that's the type of thing that could also be discussed that might be glossed over in a domain specific course like contracts, torts, property, where the language is very specific terms of art. Any other discussion on our diversity, equity, and inclusion lens? And our last slide in this area is the preparation for licensure and professionalism, which I think is one that makes the most sense as we go through. Again, but it goes back to remember Kramer's point, is everyone planning on sitting for the bar to have a licensure exam? And again, I believe that if there's any type of survey done, how many students at a registered unaccredited school wish to start, but only complete their first year? Because again, we have to take into account the first year law students exam. So here, the licensure, I think, should have a sub issue of passing the first year law students exam so they can complete their JD degree, again, even if they do not plan on practicing law ever. Again, I would always personally encourage all students, all law students, regardless of the school, even if you don't want to practice, sit for the bar, get your bar card, go inactive. You can have a bar card and not practice law. And many people do that, especially in the professional world and the political world. So on this one as examples, what evidence exists to determine whether prep should be independent, integrated, or separate courses? And again, I think pedagogically, I think that all domain bar tested content should include a bar prep component. Again, what is your final for the class? The essay, the multi, the performance type test. I'm sure it's modeled on a bar exam in the generic, but should it also be independent, and then should it be required or optional? What evidence exists as to differences in effectiveness of exam preparation is offered for credit? And again, I think unfortunately in our society, people see value in what they pay for. That's been my experience. So when we've offered institutionally free review, free this, 0 credit, 0 cost, but we don't have the same engagement as when it is a course, it has attendance and there's credit attached to it. Just like with clients in the attorney world, if you are giving your services for the benefit of the public good, it's sometimes not as respected by the client as if they had to pay for it, even if they're paying just a slight nominal scale. So I think there is a component to that. And remedial courses be required prior to law school. I think in essence, that's what law school is a remedial course as to what the modern educational system is creating. And I'm sure we could all go on and on for hours on that one, so I won't. Any discussion on preparation for licensure and professionalism as a research component? Okay, not hearing it. I think we have one more slide.
Well, let me, if I can, get inexpensive. Yeah, Jay, again, and it's an educational process. I mean, one of the things that I try to avoid in working my faculty is not to make teaching the substantive classes, particularly in the first year, teaching to the test, bar or first year review. That's what our boot camp is for. And as we all know, and not to be pejorative, but I mean, that our boot camp is intended and designed to teach students the strategies, the technique, time management. We're half the first year exam and half the bar exam are multiple choice questions, which virtually few, if any, students are asked to engage in class themselves. They pose an enormous hurdle to my students, and I think the students in many schools, and going into either the first year or the bar exam without any serious work and preparation and using the resources like Adaptive-Bar that we use and most schools use now to get students ready. They're better suited for an independent, separate course as opposed to integrating that into the courses, the substantive classes that they're taking to get ready for the exam. So again, and I hope some of my colleagues will support what I'm saying, but I think everything that I understand and have seen that's been successful, seems to say, the system works. That's another point, is the extent that this particular guideline was amended by the committee going on over 12 years ago has worked. I mean, there are schools today accredited that in part were able to get accredited because of the excellence in their bar review and their first year review. So, I don't think we should ignore the fact that, or I hope the committee won't ignore the fact that what the current system has been successful for the schools that either knew or were able to take advantage of it.
Absolutely. And I think what you just described as with the predominance and growing trend of multiple choice standardized type questions, that there could be disparate impacts that could be also discussed on diversity, equity, inclusion lens, as we've seen discussed with LSAT, MBE, and so forth. Absolutely. Any other discussion on our preparation for licensure and professionalism facet? Okay. So our next slide, please. Thank you. You're reading my mind quite literally. So sending findings to staff, and this is what I was trying to foreshadow in our earlier conversation. If it's not too onerous, I think if we put a 3-week deadline on this, that the teams must meet and create their draft submittal, no later than April 6th submitted to staff. And I'm sure staff would always appreciate earlier submittals if possible, but no later than April 6th. That would then give staff time for this to be published as part of the agenda item. So that way all interested parties, students, deans, community members can review what are our thoughts. And then they could have a much more focused public comment, either in writing or in a vocal manner at the beginning of our next meeting. Any objection to having a calendar due date of April 6th from our membership?
Can I just ask for a little more guidance in terms of when you say send findings, what do you think that would look like?
Ms. Leonard, if we could go back to the slide that has, I think it was the staff proposal with the red line edit. I think that's probably our starting point. So I think if we take that document and continue to redline it or add it, add, delete, and within each team of 2 individuals being assigned one of the 4 lenses, plus I think we should all have a look at the diversity, equity, and inclusion, because we all see that differently. So I think one of the 4 areas plus diversity, equity, and inclusion, we can put our team's proposed draft of that language. So, and that way we'll end up with 3 draft versions. And there might be consensus, you never know. There might be consensus already, but I think it's good for us to look separately as teams through these lenses, and then have that as our discussion plus what we receive for public comment in our next meeting for drafting. So the final completed work product would be, what is your recommendation for a new revised guideline 1.11? Is that a fair explanation? Or?
Hey, Jay.
Well, I think just with Dean Keller, because I was gonna make sure I answered her question. I have a tendency to go on and not answer sometimes.
Yes, thank you. I'm wondering if that meets what our charge in terms of discussing the policy considerations and other justification for allowing credit, and whether any limits should be placed on the amount of credit for bar preparation courses. That's from the CBE motion, which I thought was not limited to unaccredited schools, but was also teed up in terms of perhaps revisiting accredited guidelines or rules as well.
Well, my hope, and it's just the raw thought, but we can always come to a consensus, better answer always as a group, would be that we have this focal point for the research drafting. In our next meeting, we put together that final draft of this, and then we can have a further discussion on any other remaining points. And then we still have another meeting after that if we want to submit something by the August timeline, when the committee bar examiners will be reviewing this finding. So we'll have another bite at the apple, as it were, for any other remaining issues.
And from a logistical standpoint, if I get the 3 drafts on time, I can knit them together to show what a consolidated rule could look like. And then also, I can also forward the public comment that I receive. The groups would not be together to have a full discussion, but within your team of 2, you would be able to see the full set of public comments. So I will again strongly encourage those schools that may be watching in the audience and have an interest to really submit those comments right away.
Dean Keller, did I finish addressing it as best as I can? Okay, good.
Yeah, that's fine. That's fine with me. I just wanted to make sure that I know what we're supposed to be looking at for the next few weeks. Thanks.
I appreciate it. Dean Clancy?
Yes, so Jay, I'm looking for just a bit more in the way of clarification. As I understand it, there will be 3 teams, and each team is going to be working on each of the analysis lens. In other words, we will be coming up with comments regarding all 4 items in the analysis lens, rather than just one team assigned to one of the lens, another team assigned to another. We're going to be working on all of them at the same time, each team. And then this is an additional question, and that is, do you wish to have us come up with proposed wording for guideline 1.11 or not?
So Ms. Leonard, if you could advance our slide back to the large view of the analysis lens, purpose of accreditation. So my thought would be, if it's acceptable, that the 3 teams, each team would take one of either the consumer protection and transparency, or the student success, or preparation for licensure and professionalism. And all teams would also look at the diversity, equity, inclusion lens. So that way there would be a focal point that we're trying to drill into. At the same time, I want to make sure, that's why I was very repetitive in our discussion today about ABA, Cal Accredited, registered, and trying to, again, really highlight that distinction on the registered lens as to the first year law students exam. And that's why my proposed team composition would include, a registered dean with an accredited dean in 2 of the 3 teams. So that way, that wouldn't be missed in the translation, which I think is very easy to miss. It's not something we're normally focused on at the ABA or Cal Accredited level, because most of our students, if not all, are typically exempted because they complete their first year in good standing from the first year law students exam. So it's something we're not used to looking in. I think there was a second part to your question
The second part was related to the guideline itself. You're not looking for any wording from us in the way of a proposal.
I would actually request wording, and this is just from being a professor, a teacher, my whole life, professional life, that students, and I say also the students, we're just older students, more learned students. We're still students. There's more seriousness when we put pen to paper. I can't count how many times I've had a law student come to me and, let's discuss this essay. Have you written it? No. Well, go write it. Even if you're not going to write it well, go write it and let's come back, because we'll be emotionally invested in what we write. And I think that leads to a better discussion in our next meeting. So it doesn't have to be perfect. These are drafts, but I think if we do attempt to rewrite it, and then we have these 3 points of comparison, I wouldn't be surprised if there is some type of consensus that Ms. Leonard will see from that, coming from us, and then we can then articulate our distinctions, differences as we make a final draft for the committee.
Thank you.
Dean Keller?
Yeah, could I just ask that we go back to the slides with the teams, and maybe you could just go over exactly which, what team is doing what in terms of the 2 lenses? I know we're all looking at DEI, but I'm not sure if we already did this and I'm just missed it, or if we still need to do this.
No, we still need to, so I don't want to be presumptuous or assume anything, those are the cardinal sins for law school. So I want to make sure there's consensus, that the team composition makes sense, the lenses make sense. And if we're at that stage, then I think then we can look for volunteers within the team of, who would like to focus on the consumer protection as an example. So would anyone prefer, because I always, volunteers are always better. So if Dean Keller, since you voiced the concern, if you'd like to take the first bite at the apple, if there's one of those you prefer, then and you and your team can handle that.
Academic success would probably be one that jumped out at me. Although I'd be happy to take any of them.
I'll agree. So, but it's always better to volunteer for the one that we want, right? I think it takes away some of the emotional angst that we all suffer always. So then we'll have Dean Keller and Mr. Murphy will have the lens of student success as well as diversity, equity, and inclusion that all teams will have. I think we have consensus on that, unless Mr. Murphy, unless you have any objection. I don't want to force anything upon anyone.
Well, I don't object. I just, it seems to me that the schools may well have different missions. And so how we deal with the issue of how measuring student success and the like is difficult when you have different missions. And someone, I think it was you, Dean Frickberg, mentioned that 96% of your students want to become lawyers, and they would certainly define that as in completing their program of education and then becoming lawyers. Whereas I'm hearing others saying, well, some people just want the background law or they want the educational experience, whatever. Do we have any data? Are there any surveys of students in the registered and accredited schools about what they expect to accomplish and what they define as success?
Ms. Leonard, I don't know if there's anything that's publicly available on that, or
I mean, the ABA standards clearly say that the point of law school is to prepare students for admission to the bar. And that's in the preamble, and that's clearly the mission. That was a driver in the change to standard 316. So schools are required to meet a minimum bar admission standard. So that's clearly the goal. Now there are other goals obviously too, but that, at least from accreditation standpoint, that's the goal. But with the schools we're dealing with here, it seems to me that there are some more varied missions in that regard. And I don't know how we're going to square that circle.
Dean Keller?
I mean, as far as the accredited rules go, which I'm more familiar with than the unaccredited, the preparation for licensure just is in the rules, just like bar passes in the ABA, and of course the NPR. So to that extent, I think that bar pass, preparing people to pass the bar has to be a commonality against, across all schools, even if a certain school has a population, let's say they have 90% of their students, don't plan to practice the bar, they still have to meet that 40% NPR. So that's sort of how I look at it. Plus there's the fact that, half of our students who say they never want to practice decide at the last minute, they're just going to sit for the bar anyway, just to see what happens, which of course rarely goes well. So I totally understand I think the missions and definitions of success change, but I think, if we look at it from the lens of the commonality of preparing for the bar across all schools, I think that is something we have to do in terms of the accreditation aspect.
And I do
Well,
think
if we're looking at 40% as which is the current standard for admission to the bar, or the accreditation standard for the California accredited schools, that's less than 50% chance. So it's something I guess we'll have to work through, but I'm just pointing out that different missions, it seems to me, ought to produce different kind of guidelines. Maybe the answer is to deal with what the school's mission is and how it sees itself, and then you measure whether the school is meeting that. You develop the guidelines for whether the school is meeting its mission.
And Mr. Murphy, to your earlier question as to whether or not we have data, anecdotally, we started to look at that at one point in the past. And one of the problems we had was identified by Dean Keller, that for many people who didn't plan to practice, they did want to take the bar exam at least once to see what happened. Typical example could be a person who's a peace officer that would like to move up into management ranks, plans to spend their entire career in the force, but will take the bar.
Well, I agree that anecdotally. I'm just wondering, is there any kind of system? It seems to me there ought to be a systematic survey, particularly of students entering and then maybe after the first year. How would they define success for themselves?
Well, if I could add, I mean, again, I don't think the staff wants to take the time. The data is there because under the NPR guideline, schools are not required to count any student who doesn't take the bar at least once. And so every CALS that's been accredited under that guideline has reported over the years what their enrollment is and then what their NPR stats are. So if someone had the time or effort to figure that out, it would be interesting to see over, say, the last 5, maybe even 10 years, going on 10 years, what percentage of the CALS enrollment choose not to take the bar exam. I would bet that number is very small. And speaking on behalf of my students and registered schools, I think generally, I think it's very close to 100%. In my 3.5 years of dean, I don't think I've met a single student who has said, well, I want to go to law school just to earn a JD. I mean, everybody who applies and then is enrolled, and particularly those I've had to dismiss, take it hard because it is the end of their dream of becoming an attorney. That is really the only reason they're applying and registering and taking courses in my school. So, and I think that's, again, anecdotally, it's probably a fair statement for virtually all registered schools and almost all Cal schools too.
I think as to Mr. Murphy's point, that number might be misleading though, from what Ms. Leonard just said, because you might have a student that defines their success as receiving their JD degree, and they were going for the lottery ticket of sitting for it once just to see what would happen, even though that's not how they internally defined success. Getting the JD, getting the advancement in their current profession was the success that they were paying for in tuition as they went through. So they thought, what would it hurt? Maybe lightning will strike and I will pass. So I think that there might be some people, at least anecdotally I've noticed, and hearing that echoed from Ms. Leonard and from Dean Keller, where people might try once and then that might throw that number off as an example. And also I think Mr. Murphy, in this context, that student success, if we're defining it as a JD, which is just one possible definition, requires for the registered unaccredited schools passage of the first year law students exam. It requires it, even if they're never going to practice law. So I think that's a lens I just want to keep on making sure we're filtering through. Dean Park, you have your hand up.
Oh, thank you. I did just want to respond to Greg Murphy's question, at least in terms of program surveys or alumni surveys. Those are ways or instruments a law school, even at the registered level, can always check on our students achieving the outcomes they're expecting from their program. So if he wants to kind of see potentially more diverse result that could be from registered law schools, that could be something that's requested. But the point I also wanted to make as well, I think we're considering this guideline for bar eligible JD programs. This is not for it's not for programs that seem to be non-bar eligible. So I think that can cast some perspective. These students were disclosed, they got the disclosure and admissions, what kind of program they're signing up for, whether it's bar eligible or not. So I think what Dean Keller was saying, that there is a common touchstone here that to look at bar exam passage makes sense. Also on the 6061.7 forms, registered law schools have been needing to submit rates related to it's not the same formula as the Cal Accredited NPR, but it is some equivalent of that, and that's been happening since those forms have started. So there is some public data there that the registered law schools have been sharing.
And just echo what Dean Park said, I think that's another interesting component that many of us won't automatically intuitively think of. For the accredited and for the ABA, I believe all JDs in that sphere qualify for sitting for the bar. Versus in the registered unaccredited, there are, I believe it was sometimes referred to as an executive JD. I think that's what some schools have described as the executive JD, which was never designed for licensure at any form. So that might be an example where committee member Kramer was giving that, would that person benefit then? If they're an executive JD student, should they be required to take a bar review that by the program selection they've made, they will never benefit from, because they never will sit for the bar exam. Dean Clancy, you have your hand up.
Yes, I raised it merely to volunteer for one of the other categories. But I want to defer to Dean Park. She and I are teamed together. I was going to I raised my hand to volunteer for consumer protection, but I defer to her and I'll go along with whatever she has in mind. But on the last topic, I'd like to add this, and that is that for the distance learning law schools, there are many students who get to the end of the 4 years and they decide that they don't wish to take the bar examination. And for us, it can be due to a number of reasons. But I think one of the biggest ones is that many of our students are from other states. They're not from California. And they decide at the end that, gosh, unless they're planning to move to California, why take the bar examination? So they'll put it off into the future just in case they move to California. And probably most don't. But the point is that our population of students may have a different breakdown when it comes to the numbers who decide to take the California bar and the numbers that don't.
Dean Park, first, are you okay with being volunteered for the consumer protection and transparency lens?
Yes, that was actually the topic I was interested in volunteering.
Excellent.
That seems me as well.
So then we'll have Dean Clancy and Dean Park with the lens of consumer protection and transparency, as well as diversity, equity, inclusion, which would give Dean Leal and myself, unless objection, the lens of preparation for licensure and professionalism and diversity, equity, and inclusion. Unless I hear objection, I think we have consensus then, at least on the team membership and team assignments, with the date of April 6th as a due date. Perfect. Dean Park?
Yeah, I just had an additional comment to what Dean Clancy said. For distance learning law school, we've seen, because we're working with working adults, a promotion at their job or a change of career to another career before they graduate or after they graduate, or if they need to move states. Those are often some reasons that students, even if they reported they were going to take the California bar exam, they decide not to after the 4th year.
And I'll give one last anecdotal one. I think I've mentioned before that I've noticed, at least within the composition of the students I surveyed for my institution, that small group of approximately 4% usually includes the beneficiaries of trusts, some type of family trust, where the trust is paid out based on an earned degree at different levels. So they're collecting the JD degree to get their final disbursement from the trust. And I've seen that when I drill down and talk to them, why aren't you sitting? Because I have money now, I don't need to work. But you can still be a lawyer and not have to work. That's another argument. Any other further discussion on our assignment or our focus here?
Dean,
Sorry, go ahead, Dean Park.
Sorry about that. I should have lowered my hand. Thank you.
So going back to the first lens, which I believe is the ABA accredited, unaccredited, you're looking for, I presume, myself and Mr. Murphy to write up something or research something about the current ABA practice, and the other teams are taking the other.
Well, Ms. Leonard, if we go back to the slide for practices across school types, just for those of us that don't have the memory for it, to make sure we're all on the same page, literally. I think that we already have that information. My understanding from our previous conversation is that ABA, as well as the Accredited, are not placing restrictions in this area. I just wanted us to be conscious of, because at least I do, I know I always default to whatever I know. I work for an accredited school, I understand accredited schools. So I wanted to make sure that we're also seeing through the lens of, well, there are different requirements for hours. Again, and under BNP 6060, as an example, if it's a physical school versus a distance education school. And then how do we account for hours and attendance if that bar review course is being outsourced? That's a different lens that we normally wouldn't think of, and I think under the ABA model or the California accredited model. So I wouldn't expect any additional writing there unless someone is aware of, and I hope our deans for the registered and accredited schools would flag those issues for us as we go through, because we want to make sure this is a solid rule that we could recommend to the committee for adoption when we're ultimately done.
And if you are an accredited dean on a team or a public member, and you have a question about that, or you want to bounce your idea against that, you can always contact me, and I would be happy to do that.
Okay,
Mr. Murphy? Mr. Murphy?
Will each team be receiving a written charge from the chair on its responsibilities?
I believe it'll probably come from staff, but I'll make sure that I help in the writing of it. I'm always concerned, what are the rules for communication within these different groups? So I think if I understand everything well, that it's best for staff to center post and be the communication point to avoid.
Yeah, I don't care. I don't care where it comes from. I just want to make sure we get a written charge.
Will do.
You will, and you'll also have a shared online workspace to collaborate for your team. That will be just for your team. And it might also be helpful to ask Mr. Kramer for some feedback or guidance as to getting back to Dean Keller's question, any type of policy concern, the format that might be most helpful for the committee, or are they specifically focused on an updated guideline, since we do have that opportunity?
Well, I think the charge was because nobody can really remember why this was created in the first place, and the historical record is not available to us, to talk about the pros and cons, in general terms, in favor and not, and lay all that out, and you really don't have to debate whether it was a good decision in the past. I mean, I think it's appropriate, as someone said, to just look at it from today's perspective. That's where we are. Do we keep this thing going on? If we do, in what form? And that's where specific language will ultimately be helpful. Yeah, so I hope that answers the question.
I'll turn to the members if they have any further questions based on that comment.
Oh, just one more aspect. The specific question to be answered is, should there be some kind of limit on the amount of this credit? But the question of what is in the category of bar prep is, that's going to require a definition. For instance, can somebody get prep credit for just taking a Barbary course? Do they even exist? I don't understand the market anymore, but on their own, I would say no. I mean, that's my gut reaction, but so the definition needs to answer that question for them. There's a lot of the trend seems to be, and the desire of the school seems to be, to just define things very loosely, and to allow lots of flexibility. But at some points, there are times where we find ourselves on the committee wondering if, how we deal with situations where we think something is, is not the way we wanted it to be, but yet our standard isn't clear, and it kind of puts us in a tough spot. And I think this is, at least as to the question of how much is too much, that's something we can choose to answer very definitively if we want to.
Any questions, or Dean Leal?
Yeah, based on what Paul just said, this is obviously going to take some time and a lot of effort, and with a number of people with a great deal of expertise. And so the bigger picture, maybe the elephant in the room, is, given the benefits of what we're going to do and come up with in regard to unaccredited schools, I'd like to see this applied perhaps to relook at the CALS rules. I mean, I don't see any reason why, the registered schools should be, frankly, treated as second-class citizens in terms of what they're able to do in regard to support their students, if it turns out it's perhaps very different than what the CALS are able to do. And would like to know or hear any justification for having any difference between the two sets of rules. So if what we're going to do would support the same application to the CALS rules, I'm all in favor of that. But obviously, I would not be if it's limited only to the registered schools.
Well, and that's certainly a consideration, and you should speak to it to see that thought is advanced forward.
And just on 2 points that Mr. Kramer and Dean Leal had raised, with Mr. Kramer's point of the commercial bar review, instead of using their names, the commercial bar review, can there be credit award for that? I think there are some institutions that contract with commercial bar reviews to teach in-house. So then is there a difference if they're getting credit for being taught on their campus physically or online if they're remote, or if they have to go to another building and not get credit for it? You know, that's going to educationally, I think pedagogically, that's an interesting concept versus what should be taught. What is student success? As to Dean Leal's point, I think that any registered school, if it chooses to, can become accredited. And so long as they meet all the other accreditation rules, then they get the benefits of the accreditation standing of the rules as they currently are. But I think it's definitely worth exploring, why is there a rule at all, and what should that rule be? Dean Leal?
Well, again, and it's almost very tautological. I mean, yes, our goal has been and continues to be, and as everyone might know, we're about to transition to a distance learning school. And one of the goals will be, one of the factors in doing just that is to improve and maintain our NPR so that we would be found worthy of accreditation. To get there, however, the kind of support that my students now get, and I hope will continue to be able to get, is critical to that function. So that may play into our discussion, Jay, in regard to our submission.
And there is that goal you'll see on the goals for the Educational Standards Subcommittee to transition all of the registered schools to accredited status. I think it's going to be on there for the next 10 years unless we take it off, because that doesn't seem to be going anywhere. But yeah, that's a much broader theme that George has picked up on, and that's the differences between the two types of schools. As for the whether it's in-house or something a student just goes and gets on his own, I do see those as two different things. I'm not meaning to say that if it's a part of the curriculum, then how you get there is less important than how much of it you do, and at least in my current view.
Understood. Is there any other questions or concerns from our team members that we'd like to discuss right now?
I think I just wanted to give a quick comment. I think it's great that for whatever this is going to be used, it's great that we are centering on the 4 values, because those are pretty much consistent between accredited and registered law schools. And as to inside or outside, I think that's an interesting logistical concern. But to me, just in terms of interpreting rules and guidelines, it doesn't seem like a waiver or that guideline provides any exceptions, right? In terms of if you have a class for credit, there's nothing in there that says it doesn't have to follow the rest of the registered law school rules and guidelines in terms of what kind of course credit will be acceptable. So I think if there's a concern that that having that guideline or guideline waiver means waiving out of all of the rules and guidelines that are there, I don't think I'd be very surprised if it's been interpreted that way. And it has been 13 years since that waiver has been in place. So unless you have an example of a law school that has, counted credit for an outside course and it doesn't meet any of the 80% expectations or course design, that's a policy of the law school. I just would be very surprised. So that's it.
Yeah, but my point is that we have to say that in order to enforce it. We just can't trust that everyone's going to be good citizens, because we have examples in various places where that didn't work out.
With that, Mr. Kramer, if I could just ask your opinion, and my thought process was keeping you off the team since you will be a committee member voting on this, so that way you can still feel free to have your discussion as you want, but not required to do any of the writing at this stage, and to foreshadow what you might think later as it might evolve. Ms. Leonard is showing the lenses that we were discussing. From what I've heard from you, one of the main areas might be for us to address, should there be any limitation? And if there is a limitation, what should that limitation be? I've heard that in our discussion, at least echoed. Is there anything else you'd also like us to touch on? And again, even if it's a point of disagreement, so that way we make sure to address it and we're all on the same page for it.
Yeah, that's all that occurs to me at the moment. As you formulate this, maybe there will be more things. And I see my role here as not really to be into the making of this policy, because my vantage point is now as a retired administrative hearing officer of 12 years and lawyering before that, and law school was so long ago that I'm just happy I don't have nightmares about it. So I'm not the guy to help you formulate your recommendations, but I'm here to kind of pitch in, and if I see that you haven't addressed what I think is likely a question of the committee, I'd like to be able to point that out to you so you can do that.
Please, yeah, please, definitely. And I do like the inspirational message that there will be an end to the nightmares of law school someday for all of us that have gone through this process.
Well, as a lawyer, one of my goals was to make a witness cry. And I guess yours now is to get out of people's nightmares.
Definitely. I can only imagine. I used to joke as a quick side when I would never drive during a final exam that was being administered, because just all the bad will that people might have at that moment for me as they sat for their exam. I'm sure the bar graders might be similar in that way, but whole nother discussion. But yeah, Mr. Grammer, definitely, if the more you flag for discussion, the more we focus on it, the better product we ultimately can give to the committee. And that way, I think it's a better product for everyone at the end of the day. That is our goal. And is there any other discussion on this matter from our committee?
I'll just say that this may be practice for our review of the wider scope of the rules and guidelines.
Excellent. So with that, Ms. Leonard, I don't think there are any other agenda items for us to discuss at this time.
On mute.
I believe that will conclude our meeting.
Do we have a motion to adjourn then?
I will move. Oh, sorry.
A second from Dean Clancy, and so that will then conclude our meeting. Thank you, everyone. I look forward to seeing how our product evolves.
And
Take
thank you
care.
to all the deans for sharing information about State Bar Day, whether through email or Twitter with your students. We greatly appreciate your help in that.
Thank you.
Take
for
care.
helping.
Take care, everyone.
Thank you too.